South San Mateo County League, we are doing a joint presentation with separate discussions as this meeting. So welcome to the first, I think it's the first certainly since I've been here, of us trying to do something joint with this much technology. So have patience with us. And also, this meeting will be recorded, and the presentation portion meeting only. The discussion will not be recorded. In a few days, we will email a link to the recording to everyone who registered, so you can listen to the presentation again and share with others. Eileen, are you able to start the recording?
I have started the recording, yes.
Excellent, thank you. And so tonight we have a two-part presentation. Our host will be Eileen Easterbrook, who is the program chair for our league, North&Central, and Kathy Tyson, who is our speaker tonight. She is a longtime league member. Among her many roles, Kathy is a past president of our league and currently supports our vote411.org program. Tonight, she will be speaking in her role as leader of our local study on government transparency and accountability in San Mateo County. And she has also graciously agreed to take us through our whistle-stop tour of the federal judiciary. And we're going to start with the short update of the local study. We'll then move on to the federal judiciary study, and then we're going to, at about the halfway point tonight, we're going to break into separate breakout rooms. Each league each league member has been pre-assigned a breakout room according to your league for this discussion. And so that discussion is really to respond. It's a discussion on what we've learned, and also to respond to consensus questions from the League of Women Voters of the U.S. We will respond to questions at the end of the presentation. To ask a question, please use the chat box at any time during the presentation. Just click, there should be something that says chat at the bottom of your screen, and a box will pop up. Type your question into the box and hit return. Eileen will be presenting your questions at the end, and they'll be sorted by subject. We may rephrase or combine questions in the interest of time. And then because we won't be wrapping up together, I'm just going to say now that you can find out more about what our leagues are doing at our websites. Here are the URLs for both our leagues, and go there to find out about upcoming events. And also, if you're not yet a member, there's a join button that you can click on to join our group. We hope you enjoy this program and it inspires you to join us. And now, without further ado, I'm going to hand over the meeting to Kathy.
Okay, thank you, Tina. In League, a study is the process of research and educating league members on an issue, and then taking consensus and arriving at a formal position. So tonight we're going to be talking about two different positions and studies. The first one is our local study on government transparency and accountability. This study was approved at both leagues' annual meetings last year, and it was at County League Day. You agreed to extend it for a second year, and that will be voted on at the two annual meetings coming up later this spring. The object of our study was to look at local government races and ask a couple of questions. Where is the money coming from? Are the candidates diligently observing the state regulations about reporting and accountability? And are candidates following through with filing procedures and timelines? Our committee has about, I think I have about 18 members, probably there are 7 or 8 that are very active. What we've been doing is going through and looking at some of the races in the November election and looking at things like, where is the money coming from? Are these large donations, donations over $1,000? Are they donations under $500? Are they donations of $100? Or are they mom and pop donations? Are they coming from the candidates themselves? Because that is a thing where candidates will lend their campaign money. Are they coming from political action committees, political parties, labor unions, other PACs, or are they coming from the general public? And then how are they reporting? Because the fair practices, policy practices requires them to report all of their contributions in a timely fashion. So we've been looking at a couple of races and have some information so far. The races that we have been looking at are Measure T, which was the City of San Mateo's building that Susie Ray has been looking at that one for us. We've also looked at the 2 races in Redwood City for City Council, districts number 3 and district number 7. We have also looked at San Mateo City Council race, district seat number 2. We do have other races we do want to look at. We have someone who will be looking at San Mateo County 4th District Supervisor. We will be looking at city council races in Redwood. Yeah, those are the ones we've done. We have thought about looking at city council in Daly City, Half Moon Bay, East Palo Alto, the mayor of San Bruno, the Millbrae City Council, Brisbane School District, Sequoia Union High School District, seat number B, and South San Francisco City Council District 4, and then Measure A that we voted on just a few weeks ago on March the 4th. We picked some of these races because they are spread out over the county. We tried to pick races that were in both, that were in North County, Central County, and South County. We tried to pick some on the Bay side, some on the coast. We tried to not just stick to city councils, but to also do some of the school districts. And we thought about doing some of the special districts. We can always use help to research. And if you'd like to join our committee, just let me know and we'd love to have you. It's been a really interesting study so far, and we think it's going to get even more interesting as we start digging in to some of the other things about it. Are there any questions about the local study before we move on to the federal judiciary? Okay. The federal judiciary, this one is an LWVS study. The scope of the study focuses on the U.S. Supreme Court and other Article 3 in the Constitution courts. It's going to allow for a quick but thorough modernized study and adoption of an LWVS position to be appropriate for years to come. The local leagues will be presenting their responses to national by April 14th, and then the LWVS board will compile the results and announce a new position at the June 2025 council meeting. The study will address, but is not limited to, addressing concerns and clarifying judicial accountability, transparency, independence, and ethics. The other Article 3 courts that we'll be talking about are mainly the federal courts. They decided they would not study the bankruptcy courts and the 13 courts of appeal. Okay. So let's move on to the first part, which is judicial ethics and enforcement. The federal judiciary lacks a single set of rules for all courts and the Supreme Court. And there is a difference between the two. The 1973 U.S. Judicial Conference enacted a code of conduct for all federal courts, but it did not apply to the United States Supreme Court, which is abbreviated here as SCOTUS. There is guidance in this code of conduct on judicial integrity, independence, judicial diligence and impartiality, what is permissible for extrajudicial activities, and the avoidance of impropriety or the appearance of impropriety. Any justice, judge, or magistrate shall disqualify himself in any proceeding in which his impartiality may reasonably be questioned. Judges cannot hear cases in which they have personal knowledge of the disputed facts, a personal bias as to the case, a relationship or a financial interest with anyone who is involved in the case, and that the sanctions that will arise do not rise to impeachment. The Supreme Court says they consult this code that applies to other federal judges, but there is debate about whether or not the Supreme Court actually follows this code of conduct. They did announce a voluntary code of conduct of their own making, but it has no enforcement mechanism and was criticized from its inception. Justices make their own decision about recusing themselves from cases and usually do it without any explanation. So there is no transparency there. Two propositions have been set forth. One is an internal disciplinary procedure administered by a subset of the justices, or an external one where the judicial conference would craft a code by which the congressional statute. Potential problems with this include a lower court judge evaluating the, quote, higher up judges of the Supreme Court, and any person could file a complaint, opens it to the possibility for abuse. Proposals have also been put forward to make the justices state their reason for a recusal, and that failure to recuse should establish a formal procedure for recusal decisions to be made and reviewed by another justice or all the justices on the court. There also is a plan that reform recusal laws to make it easier for judges to avoid financial conflicts. Let's move on to structural reforms. There are some structural reforms proposed for the Supreme Court. Numerous proposals have been made in recent years. Some of the reforms would require amending the Constitution. Others are within the purview of Congress and could be done through a carefully threaded constitutional loophole. First of all, let's talk about the size of the Supreme Court. Currently, there are 9 justices. It has been that way since 1889. At other times in the court, from 1789 through 1889, 8 separate times, there were changes with a minimum of 5 justices and a maximum of 10. We have had 9 since 1889. They've decided that an odd number is probably best in the Supreme Court. That way you don't have split decisions. They're changing the size of the court could be done by amending the Constitution, but there are also other ways. Arguments in favor of expanding the court are it would prevent the erosion of democracy, and it would impact recent SCOTUS rulings that run contrary to voting rights. And it would strengthen the court as an institution and add personal and professional perspectives that the court currently lacks. It would enable the court to take on more cases. Currently, they only take on about 150 cases a year. Back in the 1980s, they were doing 150 cases. Now it's dropped to 70 or 80 a year. It would also be able to make the court respond to the increasing size of the United States population. The arguments against expanding the court is it would undermine the court's independence, and it would be partisan, which would undermine the court's legitimacy and further degrade the confirmation process. Also, expansion wouldn't alter the court's jurisdiction or its approach to judicial review. It would need at least 60 votes in Congress to increase the size. Something else that has been talked about to reform the Supreme Court are term limits. The Constitution clearly specifies that there is a lifetime tenure for judges under what's called good behavior under the Constitution. To remove a federal judge would require impeachment. Arguments in favor of term limits are that it would preserve judicial independence, and it would recognize that the judiciary is unique without retirement ages or term limits. And a fixed term might give the court more balance. That power is concentrated too much in a few individuals, some people feel. In 1978, the average tenure of a Supreme Court justice was less than 18 years. Since that time, it has now gone up to 26 years. This would make the Supreme Court more responsive to electoral reforms. Life tenure makes the timing of judicial appointments unpredictable and less responsive to electoral outcomes. Term limits could alter strategic retirements. They could also enhance the court's decision-making through a more regular rotation of justices. Arguments against term limits would be a threat to judicial independence, that it would further politicalize the court, and that there would be more turnover, and that could destabilize the court. One bipartisan proposal was that justices could serve an 18-year term, and that could be defined by statute without amending the Constitution. The unusual nature of the proposal is that it addresses nearly all the pros and cons about term limits. Moving from term limits on to financial disclosures. The Ethics in Government Act of 1978 established financial disclosure reporting requirements for many high government officials and employees, including the justices of the Supreme Court. Income from any source other than current employment by the federal government must be reported.
give us just a second. We think Kathy's signal has died. So give us a second to get her back in. Kathy, can you hear us?
I don't see that she's entered yet.
I see her.
You do see her. Okay, right.
Okay. Are we,
Kathy, we lost you during financial disclosure,
okay,
which doesn't apply to this slide, but we don't have a different slide that will work. So can you we were in the middle of
Okay.
what was required for
Okay.
disclosure.
Yeah.
Sorry.
That's okay. The internet's great when it works, right? The Act of 2022 required that Supreme Court, that judges file these PTRs, which are the transitional reports, when they make anything in excess of over $1,000. Okay. Let's move on to judge shopping real quickly. I know we don't have a slide for that. That's fine. It's real brief. Judge shopping is when somebody who is trying a case picks a court they want it heard in, usually because they think the judge will rule in their favor. That is something that happens a lot on both sides of the aisle. Moving on to recusal. Recusal is the withdrawal of a federal judge from a case on the grounds that they are not the appropriate judicial officer to handle the case because of a possible conflict of interest or lack of impartiality. Ethically, judges should not only recuse themselves when there is a possible conflict and it exists, or when there's the appearance it might exist to a reasonable person. That's a phrase they use quite a bit, a reasonable person. This applies to federal judges, but not to the U.S. Supreme Court. The U.S. Supreme Court says they have a duty to sit unless they are disqualified. Part of the reason they say this is that in the lower courts, you can have another judge from another district hear the case. In the Supreme Court, there is no such recourse. There is no one else to bring in. And they say, especially in high-profile cases, if there are 9 justices and one disqualifies themselves, recuses themselves, that there could easily be a 4-4 decision. So that is one argument against recusal at the Supreme Court level. Let's go on to judicial representation. And I know we're going through this very quickly. but it's very easy to go down the rabbit hole with these. There's so much information and it's so interesting. You find yourself getting stuck on something like, whoa, I want to know more about that. And I want lots of time for you to be able to discuss the consensus questions in the breakout rooms. So judicial representation. All federal judges are appointed by the president with advice and consent from the Senate to serve life terms, as we talked about in tenure. Currently, the status of the Supreme Court is there are 9 justices, 5 men, 4 women, 6 are white, 2 are Black, 1 is Hispanic. The legal education, 4 graduated from Yale Law School, 4 graduated from Harvard Law School, and 1 graduated from Notre Dame. On the U.S. Courts of Appeals, there are 299 judges, 202 men, 97 women. Of those, there are 229 are white, 31 are Black, 20 are Hispanic, 16 are Asian, 3 are of mixed race. On U.S. district courts, there are 1,997 judges, 750 men, 347 women. Of those, 825 are white, 130 are Black, 83 are Hispanic, 34 are Asian, 4 are Native American, 21 are mixed race. Looking at other factors besides gender, ethnicity, and race, legal education. As we said, the Supreme Court has 9 justices from only 3 law schools. They've talked about doing 1-year federal clerk judgeships, which are awarded to 3 or 4 law school graduates and are often stepping stones to judicial careers. Alumni of top law schools definitely have an edge in getting onto the federal bench. Prior legal experience. The typical justice appointed since 1970 has served as a prosecutor or other courtroom advocate for government. Only Thurgood Marshall and Ketanji Brown Jackson have had criminal defense experience. On the federal bench, in 1980, 91% of all judges were white. By 2023, that had dropped to 76%. In 1980, only 5% were women. Now that's risen to 32%. Some argue that the role of federal judges and justices are akin to that of umpires in a baseball game. They simply call the balls and strikes as they apply the law to the facts that come before them. Others feel that personal experience affects the judges and how they rule. Diversity on the federal bench is essential in their view because it is a matter of fairness for the accused and those seeking remedies for just outcomes under the law. More diverse judges may identify and reduce sentencing disparities due to implicit or explicit bias. Sentencing differences continue to exist across demographic groups when examining all sentences from 2017 to 2021. Black males received sentences 13.4% longer and Hispanic males 11.2% longer than white males. Obviously, the question here is, how well does the federal justice system represent the population? Moving on to legitimacy. The first SCOTUS decision was something that was unconstitutional, was Marbury v. Madison. back in 1803. Since then, the U.S. Supreme Court has been the chief interpreter of the Constitution with the authority to overrule actions of the other two branches of the federal government. Yet, the court has no power to enforce its decisions. If the Supreme Court cannot enforce its decisions, what happens? Well, occasionally, the executive branch has intervened to enforce controversial Supreme Court decisions. An example of this would be President Eisenhower sending National Guard troops to desegregate the schools in Arkansas after Brown v. Board of Education. In 2024, disapproval of the Supreme Court reached an all-time high. The disapproval seems to have begun around 2010, about the time of the Citizens United ruling, and Shelby v. Holder in 2013. Apart from disagreements on specific rulings, other reasons underlying the court's legitimacy problems include the politicalization of the court and the nomination process, ethics scandals, the lack of transparency in rulings, and the increased reliance on shadow dockets, which we'll get to in just a moment, and the failure of the court itself to acknowledge and respond to its growing crisis of legitimacy. Shadow dockets. Shadow dockets are a way the court rules. The court rules in two ways: written rulings. Only 1% of the Supreme Court's annual output, which is about 70 opinions a year. The other of the courts are orders. These are unsigned and unexplained. This covers the majority of the cases. 99% of what the court hears fall under this shadow docket or unsigned, unexplained orders. Orders are issued in two ways. One is granting emergency relief, such as freezing a policy or ruling during an appeal. The second way is denying something before judgment or a refusal to hear an appeal. The Supreme Court receives about 7,000 petitions for emergency appeals each year. Under the court, a minimum of 4 justices can grant centaurea to federal district courts to bypass courts of appeal and appeal directly to the Supreme Court. From 1988 to 2004, the court ruled this way just 3 times. But from 2005 to 2019, the court did this 21 times. The frequency of this practice has resulted in what's called a shadow docket. Some orders that constitute a shadow docket are being used to substantially block or unblock things. These were intended to be applications for emergency relief filed by parties in cases outside the court. These applications generally seek to enforce either a challenge statute or restrain enforcement of a court order granting or delaying emergency relief during the litigation. The impact of shadow docket rulings is not limited to individual emergencies in minor cases. Rulings on emergency applications for injunctions or stays often influence the direction and quintessential value of cases dealing with major issues, such as voting rights, reproductive rights, free expression of religion, environmental rights, and capital punishment. Some scholars say that the use of the shadow docket creates conditions for artificial rush to snap judgments. They argue that abandoning time-honored legal procedures and substituting intuitive, often partisan and biased shadow docket processes impedes the procedural foundation of the rule of law. There is also a lack of transparency in the perception of a politicized court, because shadow dockets are not signed, so you don't know which justices, voted which way. Moving on to stare decisis. This is Latin for let the thing stand. This is the precedent that a court decision can generally be found in prior opinions, similar facts, and a similar set of legal issues. In practice, what this does is it gives citizens and parties an understanding of what the law is, what the law is likely to be in the future, and it allows for certainty in some business transactions. The American Bar Association defines two types, vertical and horizontal. Vertical is when lower courts are bound by decisions of the higher courts. Horizontal is when courts at the same level are influenced by decisions of similar courts at the same level, but in different jurisdictions. And then there's what's called a super precedent. The law is thought to be settled enough and not at all changeable, except in extraordinary circumstances. One well-known super precedent is Brown v. Board of Education, because it invalidated Plessy v. Ferguson of 1896. Similarly, Roe v. Wade in 1973 was considered a super precedent until Dobbs v. Jackson Women's Health came down in 2022. The concept of strictly following precedent is being challenged, and federal courts appear to be more willing to step away from strict adherence to the rule. This has led to federal courts limiting many well-established rights, such as voting rights. And that's the formal presentation I have. How are we doing on time?
We're pretty good.
We have some time for questions.
Sure.
Thank you, Kathy, for an excellent summary of a lot of material.
Well, like I said, it's really easy to go down the rabbit hole and fixate on one thing like shadow dockets. It's all so interesting. We didn't have a whole lot of time with this study. We got the materials from National February 7th. So it's been kind of a rush to get it all compressed and out to you, because we have to have them back by April. And I was really excited about this study and thought it was really important that we participate. And so I'm really glad that both our leagues are able to do that.
Yes. Eileen, any questions for Kathy?
We have one question, but I don't know if time will allow if this is a quick question or not. So we do have one. What is the process to enact SCOTUS term limits by statute?
It would have to be passed, from what I've read, by Congress, and it would need a majority of 60. Plus, you would have to have something to say. The bipartisan proposal for the 18-year tenure is thought to have the best chance of passing.
The reason it's thought that it might be constitutional is that there would be the judges that time out would still be justices, but they wouldn't be active justices. And because Congress defines the role for justices, it's thought that might be constitutional.
Okay, any other questions? That was the one question in the chat.
And I'm sorry, I'm not an attorney, so I don't understand a lot of the special things of the law.
Okay,
Okay, the consensus questions are fabulous. You will really enjoy your breakout rooms. I think you're going to have some wonderful discussions. And I really want to thank you all for coming.
okay, I'm going to transfer you to your breakout rooms. And I'm going to check here, make sure you're listed. If we've put you in the wrong breakout room, please send me a chat. Please chat that you are in the wrong breakout.
So,
The two rooms are divided between North Central, and then South County has its own. And I pre-assigned based on how you answered your questions when you registered. Anything else, Tina?
yeah, just if you feel like you're not in the right room, message or send a chat to Betsy or Eileen, and they'll work to reassign you. And I think we only have members here, am I right?
I don't know.
Okay, if you're not a member, you've been randomly assigned to a room, which is fine, and we welcome your participation. I'll just say that we're going to be making responses coming to some consensus decisions. The consensus decisions will be based on member input, but we do welcome your participation and in the discussion. Thanks for joining us. Okay, I think with that, we're ready. You should eventually see a button that shows up to say join breakout room, and click on the button.
Yep, I'm going to open the rooms now. It looks like 4 are unassigned. I think you can stop recording also. Thank you. Yes, I will. We are stopped.
I do not see